versus Alante Lovely.
Allie Zenda on behalf of the people.
First Assistant Public Defender Kalina Anderson with it on behalf of Ms. Lovely. Ms. Lovely, can you state your name, please?
Yes, good morning. Alante Lovely.
And Your Honor, in this matter, we're requesting a preliminary exam, and at the appropriate time, may I address our bond, please?
Yes, I don't think I've addressed this yet. You did see there. Did we address the social media post yet?
No, Your Honor,
Yes.
those were posted. There were other posts after we addressed it the last hearing.
No, you got to be kidding me.
There were two posts. One that was my stalker is playing victim. Good thing I'm a survivor. And another post that said stalker is on the move on July 28th, which was after the hearing on the 27th. And then the GoFundMe was also never taken down.
You want this set for a preliminary examination, is that correct, Ms. Anderson?
Your Honor, I was asking for a preliminary exam. I had spoken with Ms. Kirby with regards to violations and was told that there were no bond violations in relation to social media. So I just asked to confirm if that was before or after these additional ones that were just read off.
They were after, and I put you on the email when I submitted the motions, and I don't have an email where I said there were no violations. There were violations, which is the reason why there was no offer, which is what I said in my email.
Okay, I'll have to double check that. I had something different in my notes. So yes, Your Honor, we are asking for an exam. I'd ask that any bond violations be set over with that, so I have an opportunity to speak with Ms. Lovely.
Well, that's going to be a problem because I'll just tell you this. I'll set preliminary examination August 29th, 2023, 9 a.m. That is before me. And I'm were the previous postings removed?
Buckle up, guys. Today we're going to witness a courtroom moment that flips from routine to explosive in seconds. What starts as a standard hearing suddenly turns tense when the prosecutor reveals new social media posts made after a direct court order. The judge's tone shifts instantly. You gotta be kidding me. In that moment, you can feel it. This isn't just about posts anymore. It's about whether someone ignored the court.
I believe everything else was removed except for the GoFundMe, but then she posted after the hearing on the 28th, the new posts.
I don't believe this. Here's my problem, Ms. Anderson, is the last hearing, what may have been inappropriate post and other things, I allowed this defendant to remain out, admonished her, told her exactly what to do. And now I'm looking here and just must think I'm playing. And that I don't mean what I say. I don't know. Your client wants to say something. If she wants to say something, you know what? I'll give you a breakout room to talk to her.
Okay.
Before I do what I'm going to do. But I'll hear from her. So put them into a breakout room, quarter past the matter.
The judge's patience visibly thins as he reminds the defendant that she was previously given a chance and clear instructions. From the bench, he makes it clear he feels tested. He states that he allowed her to remain out on bond and expected compliance. Instead, he's now facing new allegations of violations. Before making a final move, he allows a private discussion, but the warning is unmistakable. Consequences are coming.
Good afternoon. Court does call the case. People of the State of Michigan versus Alante Lovely.
Allie Zenda on behalf of the people.
First Assistant Public Defender Kalina Anderson with it on behalf of Ms. Lovely.
All right. So I've set the exam. Now, where are we with regard to this bond issue?
Your Honor, I had a chance to speak with Miss Lovely, and she indicates to me that the postings don't have anything to do with this case. I had a chance to review the motion as well as the documents that were attached. I don't see anything specific that's naming any particular person involved in this case. She's also indicated to me that she has taken everything down. We had a detailed discussion about not posting about this case and not posting at all, and the potential for deactivating the account in its entirety while this matter is pending. She is concerned as she's scheduled to have some visitation with her son next week. She's hopeful that Your Honor will give her another chance with regards to this, especially now that she's taken everything down. Other than that, Your Honor, we don't have anything additional to add.
Is the child's name Alan?
That's his middle name, Your Honor.
So explain to me this Love and Company LLC thing.
The Love and Company LLC is just my company, my production company. What was shown to me was my profile link called Tap Link, which goes from my social media to this various profile. However, the same day that I got from judgment from the last court, I took that down and updated that document to my public defender so she know exactly what it looks like now. And it doesn't look like that anymore. I've taken everything down, removed all the links that I had associated with any shares or comments or any post that may or may not have been related. And that's been since she told me to do that.
What case is that first post related to? Give me a case number. Says it's related to something else. Give me a case number so I can look
Your
it
Honor,
up.
it's
Because I
not a
don't believe
case.
that for one. I don't believe it for 1 minute.
Your Honor, that as I discussed with my public defender, I have been going through a different matter with my landlord.
Give me a case number.
That situation was an eviction case. And that the moments that I had with the bullying, harassment, and stalking from my landlord was a situation that was referenced.
Give me a case number.
I can give you the eviction case number associated with my apartment and the letter that stated that she's no longer around because of the situation. That's the only thing I can give you at this time. There's other things that's going on. I'm dealing with various things, but that was an old post that has been taken down that had nothing to do with this case and nothing to do with that case now either. Everything has been taken care of.
Anything else from the people?
No, Your Honor, just that I believe when the victim reached out to us, he said those were posted on July 28th from the screenshots. So I'm not sure exactly what those would be, but that was the date that we were given, but that's all from the people.
So, ma'am, when were these posted?
They're not since deleted. I don't know the exact date, but it was when I got the notice on my door from the landlord that stated, again,
When was that?
that was July. It had to be near the end of July. There's a lot of things that are circling around this matter. So correlation, can I say it was right after that date? No, because I was in the process.
I'm not believing any of this.
I'm sorry to hear that.
So, well, you may be. Ms. Anderson, anything else you want to say?
Your Honor, I would ask if you would consider giving us some additional time if we can substantiate any of the eviction information or when that letter was presented to my client to try to pin down those dates for the
Well,
court.
she's gonna have about 5 hours to get it to you. I'll set a hearing on it, but right now, I gave very specific instructions on July 27th, what she was supposed to do. I expect my instructions to be followed. I don't expect this to come up at all. And if you want to play fast and loose with the court's orders, or how you think about how the court's orders are, or what you're going to say regarding it, well, you can do that if you want, but you better be ready to go if you're going to come up against me on my orders. Defendant's bond is hereby revoked. Defendant is to report to the Washtenaw County Jail by 6 p.m. this evening. Her failure to do so will result in a bench warrant being issued. I will set a bond hearing on this.
Bond hearings next week at 3 o'clock, 24th at 3 o'clock.
I'll set a bond hearing on this for, that's 24.
Yes, sir.
Bond hearing on August 24th, 2023 at what time?
3 p.m.
At 3 p.m. in person. So, ma'am, I'm just going to give you a fair warning. If you think I'm not, you didn't think I was serious about my last order. If you think I'm not serious about this order, you're going to find yourself very wrong. Because if you're not in that jail by 6 p.m. this evening, I will send somebody to get you.
I understand,
you.
Your Honor. I'm sorry that you feel that way, and I hope we can resolve this.
You
matter.
better be quiet, because she's about to pick up a whole lot more, Miss Anderson.
And I'm sorry, Your Honor, I didn't get the exam date.
The exam date is on the 29th. Bond hearing I'm setting for the 24th at 3 o'clock.
Thank you, Your Honor.
As the hearing resumes, the defendant attempts to explain the posts, claiming they were about a landlord dispute. Not this case. The judge repeatedly asked for a case number. Pressing for proof, the answers grow uncertain. The prosecutor references dates that placed the posts after the last hearing. The judge openly states he does not believe the explanation. Then the hammer falls. Bond revoked. Report to jail by 6 p.m. or deputies will come get her.
Michael Johnson.
Good afternoon, Your Honor. Marcia, on behalf of Mr. Johnson.
Yeah, Mr. Sinatra for the people.
Mr. Johnson, can you please state your name?
Michael Johnson.
Your Honor, we are here again. Mr. Johnson is supposed to have turned himself in at the Washington County Jail per our last hearing, and he has failed to do so. There is no excuse for not adhering to your court order. My client does want to offer this, that if he is incarcerated for a period of time, he will lose his job with the apartment complex that he is at, which he works for in exchange for his apartment. So in essence, he fears he'd be homeless.
Well, I'm not negotiating against my order. He needs to turn himself in. He doesn't get to make the rules. It's really as simple as that. So I'm just going to leave the bench warrant out. I'm not going to set another hearing date because he comes here, tries to give me an excuse and tries to get me to negotiate. We will get him and I will remember. And if he thinks there's a jeopardy of him losing his job, given that he is not complying with the court's order, it's going to be very hard pressed for me to release it. So those are his choices. I'm done. Bench warrant stays out, no bond. This is Axel Lopez.
Ray Ursinski on behalf of the people.
Good afternoon, Your Honor. May it please this honorable court, Ray Richards on behalf of Mr. Axel Lopez, who appears via Zoom with consent.
Mr. Lopez, can you state your name, please, sir?
Axel Lopez.
All right, very good. Thank you. All right, what are we doing today, folks?
Judge, we've received discovery as of yesterday evening. We received the first offer in this case. I do believe we're very close, Your Honor. I would ask for another 2 weeks just to make a counter offer, or at least see if we can amend the terms to come to a resolution, Judge. But we're very close.
All
And
right.
Your Honor, just so defense is aware, I will not be changing my offer. This is a felony matter that I've agreed to reduce down to misdemeanor, so there will be no counter offer. So you can send the email and I will consider it, but as of right now, that is going to be the offer.
Okay, Judge, well, I guess I'll just be sending the email.
Well,
Uh,
at least you know what's coming back.
I don't
It
know
could be
whether that was
nothing. Don't worry about it.
well,
All
I
right.
mean, you know, I just
You
have
never
a
know.
request. That's
Yes.
right, unless you ask.
That's right. September 7th, 2023. 9 a.m. or your Zoom invite indicates bond will continue. Thank you.
Thank you, Your Honor.
Your Honor.
Have a good rest of the day.
All right. Oh, no. Don't say it, Marie.
Oh, no, I was going to bring up a community corrections report for that case.
Oh, on this case? Oh, I'm
Yes.
sorry.
There was
He
one
left.
from August. Well, okay.
It's fine.
There was one
The
from
defense
August.
attorney left, so I'll notate it for the file for next time.
Okay, thank you.
Okay, he has another file, correct? Is that what you're saying?
No. I said I would note the file
Okay,
for next time. Yeah, we can bring it up next time.
okay, next time around. All right, thank you. All right,
Thank
folks,
you.
been quite a day. All right, everybody, appreciate it. Marie, I won't see you the rest of this week, but let me just tell you something, young lady, and I do mean this from the bottom of my judicial heart. You have been before this court handling hearings all week, handling some of them by yourself, even though your supervisor wanted to step in when it was not really necessary, but we won't go into that. Again, and I just want to express that I think you've done a wonderful, great job handling the cases. You handled the whole docket yesterday and did it admirably. So I think when people do good things, I want to tell them, just like when I tell them when they don't do the right thing. So good job, young lady. Did she freeze? That was a wonderful statement, and she froze.
It was a nice statement. I'll make sure that she knows.
All right, very good.
In the very next case, another defendant faces a court after failing to turn himself in as ordered. His attorney warns that jail could cost him his job and home. The judge refuses to negotiate, stating clearly that court orders are not suggestions. Compliance comes first. The message is firm and direct. No bargaining against judicial authority.